Greetings, friends. My name is Jonathan Ware, and I'm here bringing you Enlightening the Law, a legal commentary designed to help you comply with the myriad of legal issues that your business faces. And today we're here to talk about email and internet-based marketing. Email and internet-based marketing are the most efficient and effective means for most businesses to reach their customer bases and to communicate with them. And these methods of marketing actually have the lowest acquisition cost of any other marketing method that are available today. So they're very attractive and popular for businesses to use. But in using them, you want to ensure that you comply with all of the federal, state, and international laws that apply to email marketing. Here in the United States, one of the most stringent laws that applies to all businesses that conduct commercial email solicitations is the CAN-SPAM Act of 2003. And the CAN-SPAM Act imposes penalties of up to $11,000 per violation, as well as criminal penalties for emailers that undertake deceptive practices such as spam practices. So you'll want to make sure that your email communications follow the provisions of this law and don't fall within the prohibited activities contemplated by this act. The CAN-SPAM Act is administered by the Federal Trade Commission, which is the nation's consumer protection agency, and the Department of Justice is also given enforcement authority under this law. State attorney generals also have the ability to enforce the law, and internet service providers can sue to enforce the provisions of the law as well. Among other things, CAN-SPAM bans the use of false or deceptive headers in emails and also bans deceptive subject lines in email solicitations. Most importantly, CAN-SPAM requires all senders of commercial email solicitations to include an opt-out mechanism. That is, a mechanism by which customers may remove themselves from your email list. And once you receive an opt-out request, and the opt-out mechanism, it has to be internet-based. Once you receive that request, you have 10 days to remove your customer from the list and not to send any more emails to that customer. CAN-SPAM does include exceptions for transactional or relationship messages. That is, messages that are designed to facilitate a transaction between you and your customer or to communicate about a transaction you've agreed upon that's already in existence. So you'll want to make sure that all of your transactional messages fit within the parameters of the CAN-SPAM Act and this permitted exception. CAN-SPAM further provides that all commercial email solicitations be identified as such, be identified as advertisements, and that the sender's valid physical postal address be included in the body of the email communication. For businesses that conduct email solicitations internationally, you'll want to make sure that you comply with the local laws in the countries in which you're conducting those solicitations. If you're conducting solicitations in the European Union, the European Union Directive on Data Protection and local implementing legislation applies. If you're conducting email marketing in Canada, you'll want to make sure that you comply with PIPEDA, the Personal Information Protection and Electronic Documents Act. You'll also want to make sure that you have a carefully constructed privacy policy and a plan for addressing any type of data security breach in which your customer information is compromised. All of this will help you to conduct internet-based and email marketing with safety and security, knowing that you are in compliance with the law. This is Jonathan Ware wishing you happy and safe emailing and bringing you Enlightening the Law, illumined legal solutions for your business.